Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, speakers on Virtual Amicus are chosen keeping in mind the topic for the session. So first we decide the topic for the session and accordingly we go on a hunt, we look for an expert who would deal and discuss that session because on the Virtual Amicus we believe in taking assistance from experts in that very field, people who are specializing in that field, who are working in that field, who have a degree, who are specializing or who are even teaching for that matter. So today topic for discussion would be on basics of power sector, the energy laws. And since this is a very vast field, so we'll be talking about electricity laws in particular. And joining us today on the virtual amicus is someone who needs absolutely no introduction in this field. He's an experienced counsel with a demonstrated history of working in the law practice industry, skilled in legal assistance, arbitration, dispute resolution, legal research, and legal issues. And just to give you a brief introduction about our Amicus for today's session, today we are joined by Mr. Varun Pathak, sir, who's a counsel at Shardul Amarchand Mangaldas. And prior to that, sir worked as an independent legal practitioner. He's also served as a guest faculty at Symbiosis Law School, Noida. And prior to that, he's also worked as a manager with DSK Legal. And as far as education is concerned, sir has done his master's LLM in corporate commercial laws from the very prestigious London School of Economics and Political Science, and he's also he studied law LLB honors from Guru Gobind Singh Indraprasth University. So first of all, thank you so much, sir, for taking out time for doing the session. I know it's a Saturday afternoon, and it's a different sort of a Saturday for you. Joining and taking out time for the virtual amicus in this Q&A format on the Q&A segment on the power sector. Anything, sir, that you wish to say before we start with our segment?
Hi, Jay. It's a pleasure to be here. And I hope whatever I say will be relevant for people, whoever will watch this show. Now, just before we begin, I would just like a couple of minutes just to explain certain things in a very layman's terms and a very practical and pragmatic manner so that when people are trying to understand what are the issues and how we proceed in the power sector, they will be able to identify with issues and things which they see in their daily life. So practically, if you see, the power sector is a combination of four different type of players. Primarily, government is a very important player. So government is there in its role as an advisor, as a trend setter, as a policy setter. Then you have the regulators. The regulators again, and their job. You have a central regulator and a state regulator. They play a very pragmatic role at the central level and also at the state level. And then you have licensees and generating companies. I'll club them together. They play a huge role in the way your power sector services and the power sector is run. And the fourth and the most important one is the final consumer. Now, if for any country to develop, and this has been found in various studies, that any developed country is developed because it has a very high per capita consumption of power. So there is a correlation in between power consumption and the development index of a country. Now, just simplistically put, a generating company is one which generates power and is responsible for starting the generation process and putting it into motion and putting it into the various lines, which is then brought to us. You would have seen, everyone, we all travel and we see the high powered lines. So when once generation is done, it is depending on the voltage it's generated at. It's either stepped up or very few times, maybe sometimes even stepped up, and then it's transmitted through the high powered lines which you see across the country. We have a national power grid, which is the central transmission utility, and we also have state transmission utilities for each state. Now, there's a good reason for power to be transmitted at high voltages because the loss of power is quite less. But at the high voltage, it is transmitted and it's taken to its final consumption point. the 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 voltage has to be changed. So once it's transmitted at high voltages, which reduces the losses, it is taken to the final consumer within the peripheral distance. There you have a distribution licensee which is in touch with the final consumers, and they provide the service. So, for example, in Delhi we have BSAS, uh, Rajdhani and Yamuna. In Mumbai we have Adani. We earlier it was Reliance. We have Tata's. We also have MSCDCL. In Haryana, we have uh, Dakshin Haryana, we have Uttar Haryana. So each state has a distribution licensee, which will then take the power to the final consumer. So for the power which is traveling at high voltage is then converted into and stepped down into lower voltage, and then from the substations or the distribution licensee, by the time it reaches you at 11 volts. So it will keep getting stepped down. There would be some sort of electricity losses, and then you get the power that we get. So this is the basics. That power generated, then it's transmitted, then it's distributed, and then eventually consumed by the final consumer. Now, in terms of the scheme that we have, in terms of the enactment which is there, we generation has been delicensed. So power being very essential to the development of the nation, you will see that as the country has become more developed, it's still a developing country, but as it has become more developed, there have been various aspects which have been liberalized. So the initial enactments, when we were colony for the British Empire, there was a 1910 Act. There were very few private licenses, and once we got independence, because power is an important infrastructure, and it's also necessary for the security of the country, we had a 1948 Act. Now, in the 1948 Act, and there was a 1910 Act. 1910 Act basically meant that even private people could start, and the technology at that point of time was largely based on fossil fuels. So in 1948, the and because it was also uh, dependent on the state, and the thought process at that point of time was that state would be better off in undertaking these big infrastructure projects. So the 1948 Act, what it did was that the generation, distribution, transmission, everything was largely done by the state electricity boards. Now the idea was good, as was with the 5-year plans. But what effectively happened was, because of political reasons, these state electricity boards started becoming very, very inefficient. Now, because they became inefficient, so they were not selling power on a commercial basis. When I say a commercial basis, what it means is that you are getting power at 10 rupees, but you were selling it, for example, at 5 rupees. So there was a loss of 5 rupees. And a lot of this power was subsidized because a lot of power was getting consumed for industry and agriculture. So agriculture was always a priority. Fertilizers were always a priority. So what started happening was, because state also only has so much revenue, state also does not have unlimited coffers. So initially there were freebies which were being given, but then after a point of time, it started becoming unsustainable. So once it became unsustainable, and there was no way that any further freebies could be given, there was a thought process, and this culminated in the liberalization in around 1990, that where we almost became bankrupt, where we had no choice but to liberalize the economy. Then it was thought that we should encourage private generation, and one of the aspects was that there should be some sort of captive consumption. Now, what they wanted to do was that people who are consuming, so power is an um, input material in a lot of industries like steel and other heavy industries. So what they thought was that still people who would set up, it was not permitted earlier, who would set up plants for their own consumption, they should be given some sort of a rebate, some sort of a encouragement, where if they generate and if there is a surplus, that surplus should be given for general consumption, and this power should be cheaper for them. That was the thought process. And also because the general freebies had become completely unsustainable, so they thought that we should have a cost plus model. Now, how a cost plus model works is that you will see various aspects. You will see what are the different expenses which go into running a power plant, or the balance sheet of a licensee. And then based on what, it's something similar to a budget. So based on what requirements they have and how much revenue they will generate and how much sales they will make, there is an annual revenue requirement which gets computed by the commission. So what the government of the day thought of was that let's ensure that there is no exorbitant profiteering, and we can divide the cost aspects and give them a fixed return, and that should make the power sector sustainable. So they came up with the 1990 Electricity Regulatory Commission Act. Now, in 1998, the commissions were created, and what also happened, there were around 7, 8 states which independently, because electricity is there in the concurrent list, so both the state and the central legislatures can frame the law. So there was central regulatory commissions, and there were certain states which then also undertook reform. Odisha was there, Haryana was there, Gujarat was there, Delhi was there. Multiple states, they undertook reform and passed their own laws, distancing the government from power generation supply, and and tried making generation a private activity. But one of the issues that the regulators of the day and the government of the day faced was, and even the courts, judiciary in that sense, that the appeal from these regulators was to the High Court. Now there's a matter in 2002 which reached the Supreme Court. Justice Santosh Hegde was there on the, I think it's CESC versus, I think if I'm not wrong, it's a Bengal matter. So there the Supreme Court said that these are technical matters. High Court judges are not equipped to go into tariff orders and look at so many technicalities. So the best possible way, and the government of the day would be well advised to consider, is that please have high-powered tribunal where one person is there from the power sector who has seen these things and has the technical expertise to understand what goes into all these aspects of power planning, power consumption, power generation, and creation of infrastructure, and have a judicial member who the chairperson would either be a retired chief justice or a Supreme Court judge. And that is how the appellate tribunal came into being. So the central government of that day then took this advice seriously, and they passed the Electricity Act, where the appellate tribunal was created. This is how your Electricity Act came into being. Now, one of the legacy issues which we still face is, after years of abuse of giving freebies, the balance sheets of all these state utilities had become unsustainable. So these utilities were then hived off as like different types of licenses, because state board were basically undertaking all the functions together. So what the act did was then bifurcated these functions. So generation became, other than hydel generation, and nuclear is beyond the purview. Nuclear is completely different. Other than hydel generation, where you still require an approval and prior studies, CAs involved, all other forms of generation became delicensed. But the transmission activity, the distribution activity, all these functions were hived off into different utilities. A lot of these utilities were again controlled by the state government, but at least some parts became privatized, and there was some sort of systematic way forward where things started attracting private investment. But because they were a continuation of the previous state boards, there were past losses which couldn't be written off because they were huge losses. Like two typical you will see two typical projects which are loss making but as still being continued. Is one of the Enron scandal which was there, the Dabol. Now because of, so just I'll just deviate slightly and I'll say it in common terms. The cost of creating a project and the amount which is there is what the project, the banks will then finance it and they will close the cost at that particular amount. Now, if for certain reasons the amount has gone up for delay or for other reasons, the project cost has gone up. Now, this project cost, now the project would be viable for maybe, depending on the type of project and the type of technology, sometimes 15 years, 20 years, 25 years. So this cost will, with your operation and maintenance and administrative and general expenses, along with a return on equity, would then be divided amongst that period of the which is there for the entire duration of the project. So for example, if it is 25 years, so you will divide this cost plus the other expenses I said, and they will be then divided in terms of units, and this is what the cost will be and the commission will determine. And based on that, this will be then be consumed. Depending on how you consume, the consumer will eventually pay the cost for this. So because of the past losses, they what creatively what was done was commissions everything. So the losses were treated as regulatory assets. Now this is kind of an oxymoron. It's a loss, so ideally it should be reflected, but that would have made the companies unsustainable and it would have made them bankrupt from day one. So they were shown as assets, and then these assets were liquidated up to 10%. So there would be a tariff hike, and eventually this was consumed. So whatever was given away for free was then effectively hived off to the consumers, and this was made part of the tariff. And I don't know if I've not checked recently, but there would still be regulated assets, though very less. But this is how the past losses were written over. So whatever was given for free. So if you've taken a loan to pay 100 rupees, you've taken a loan for 100 rupees, you then also pay interest. Then the consumers are also paying for the 100 rupees loss plus the interest, the banks, and this would then get transferred to the consumer. So that's how, because of legacy issues, we still have, for example, if you see the cost, there's a cost differential in power in Delhi, in Gurgaon, in Noida. They are in the same region, so the cost should be similar. But because there are different licensees and different regimes, the cost is different. So for example, when the cost of power in Delhi was around 5.5, at the same time in Gurgaon it was around 7. That doesn't make sense, but that is how the cost plus model works. So you see the entire area that is being serviced by the distribution license, you see their power procurement cost plus other expenses and the number of sales, the number of consumers, and then you divide it, amortize it, and then you get, largely you arrive at a tariff, and then you will check up whether what the projections were, whether they were met, whether there was some sort of other loss or profit which will then be accounted for. So that's largely the principle. This is how the cost plus model works. So now with this background, and I'll explain as and when required, I'll clarify on certain aspects. Now we can proceed.
Very well, sir. So if you're ready, can I ask a couple of questions that I have?
Yes, please.
So, number one, since you beautifully elaborated the provisions of the Electricity Act and explained them in simple language, so if you could explain to all the viewers who are watching the role of Central Electricity Regulatory Commission, sir, because we keep hearing this over and over again. What exactly is the role of a Central Electricity Regulatory Commission, or even State Electricity Regulation Commissions for that matter?
So, like I said, so when the entire scheme was thought of, so now you have two regulators, one at the central level and one at the state level. Now, the state regulator, as the name suggests, is there. Actually, we also have a regulator for the union territories, which is the Joint Electricity Regulatory Commission, but its role is similar to that of the state commission. So JERC and SERC are at par, whereas the CRC's role is slightly different. So Like I said, the functions. So at the central level, so CRC's role is that of a facilitator and a policymaker. So CRC in that sense is the first amongst equals. So their role is one to determine the tariff, because there were a lot of central PSUs like NHPC, NTPC. There were projects which were then servicing multiple states. So then to have different states determine tariff would lead to maybe disastrous results, and each state would want the cheapest source of power. So sometimes it becomes unsustainable. So you have a, in that sense, a distant neutral regulator where they will determine what the cost is, and then based on that cost there would be an arrangement, and that power will go to different states. So one of the functions of the central regulator is to determine power for central generating stations. That's one. Two, where there's a generating company, for example, even if it's a private generating company, but it's supplying power to more than two states. So there's an interstate scheme. Where there's an interstate scheme and power is being generated, there a central commission can determine the tariff for supply. Now, there is also a provision under, I think, 64.5, section 64.5, which says that irrespective of interstate nature of supply, a state commission can still have jurisdiction. So, depending on how many states are there, or uh, what the other factors are, the jurisdiction for determination of tariff will then change. Sometimes it will be the state commission, sometimes it is central, but that's largely the principle. Now, again, if you see, we all would have read that there was some sort of conspiracy which was alleged against the Chinese, where they said that they shut down some parts of our transmission network. So now, if you remember, there was a blackout for the northern grid. So to ensure that there's grid security and grid monitoring at all times, and there's safety. So the transmission at the national level, that is within the domain of the central commission. Now, just as an analogy, and since you were a student, you would understand that when you students would have parties, different people would get in when you're getting your own liquids. So different people will get different types of liquids, and like in a punch bowl where you pour everything together, and then everything gets mixed, and then you will take it out, and then it becomes a concoction. Similarly with electricity, because it's produced and consumed almost instantaneously, though there are some technologies where you're trying to store electricity, but largely consumption and generation of electricity is instantaneous. There's a constitutional bench judgment also. I think NTPC by Justice Lahoti was there. I think it's 2002. So the nature of electricity is such that it's generated and consumed instantaneously. So like in a party where there's a huge punch bowl, everyone pours their drinks into that, and then once it gets mixed, then you take your drinks out. Similarly with electricity, everyone connects to the grid, feeds the electricity, and then whoever takes it out, then takes it out. But then you determine the charges, the transmission, how much to charge them for the conveyance of electricity, depending on various formulas. So there are regulations which are point of connection charges, and there are different regulations which CRC has come up with scientific methodologies to charge for the transmission, which is happening all across the country. Now, transmission assets, so sometimes there's a mismatch. It's like basic electricity. Sometimes they are not able to take the huge amounts of electricity. So the creation of assets, creation of licenses, creation of infrastructure at the central level, all that comes within the domain of this central commission. And finally, the functions of CRC are there in 79F. So finally, if there is any dispute regarding any of these aspects between licensee, generating company, transmission utilities, even involving generating companies, the central generating ones, or companies which have an interstate scheme, even with distribution licensing, then the CRC will have jurisdiction. And in 79(1)(f), they can even refer the matter to an arbitration. Now, arbitration, I'll just come back to this after I explain the SCRC, because arbitration is very unique to the power sector in the way it works. Now for the state regulator will determine what kind of policies are there. So the regulators, both central and state, have largely three kind of functions. One is adjudicatory, where they'll adjudicate disputes between licensees and generating companies, or interstate between licensees. They have advisory functions. They advise, the CRC advises the central government, the state commission advises the state government on various aspects. And regulatory. So now regulatory is under 178, which is for the central commissions, under 181, which is there for the state commission. They have a regulation making power. Now, this regulation making power can even override contracts. It's delegated legislation. Now, the central commission's regulations are laid before the parliament. Parliament can make changes. The state commission regulations are laid before the parliament, but before the state legislature. But the state legislature cannot make changes. That's the fundamental difference between the regulations made by the central commission and the state commission. Now, once these regulations come into being, there was a constitutional bench judgment. I think PTC versus CRC. Justice Kapadia was heading that bench. There, the Supreme Court said that where the regulations are there, they can even override contracts. So various parameters, where various rules and regulations are then prescribed by the central commission or the state commission, which then become applicable in the regime as to how licensee generating companies are regulated, and different technologies. They will prescribe that these are the norms. So under 61, so the central commission's norms are then, they act as a guiding force for each state regulator, because each state regulator will be in a different footing, different place. So for example, if you see in Himachal, there's a lot of hydel generation there. Whereas for Chhattisgarh, there would be a lot of fossil fuel. In Maharashtra, there would be a lot of wind energy. In Tamil Nadu, again, wind energy. And even in Rajasthan, there's a lot of wind energy, wind and solar. So each state will have a different parameter, different regime, different kind of circumstances. And then they'll take guidance from the central commission, and then they'll make their own rules and regulations for the state. So there was a matter of which traveled from Rajasthan all the way to the Supreme Court regarding captive generation and solar generation. So what the Supreme Court said there was that the right to clean energy is part of the directive principles, and is part of enshrined under the obligations, the fundamental rights, and therefore was at the highest pedestal. So all these things, the state regulators will then look at the transmission at the state level, the issues between distribution licenses, the issues pertaining to consumer. The state regulators also have a fundamental duty for regulating open access. Now, open access, this is there in section 42. So there are two, actually, one is a transmission open access, where you get access to it's like, in simple terms, where you get to use someone else's asset and you pay a rent. Now, that rent, there will be different nomenclatures. There would be wheeling charges and different aspects as to when you're using that property or those lines, you will have to pay different charges. Those charges are calculated by the regulators at the state and the central level. Now, once the state commission also has a duty towards the consumer, because ultimately the distribution licensee is connected to the consumer, and the distribution licensee is within the jurisdiction of the state commission. So therefore, the obligation of the state commission is to ensure that the open access consumers have access to both the distribution network and the transmission network. So at the central level, where you're seeking access to the central transmission utilities level network, and you're seeking open access at that level, there you go to the central commission's regulations will apply. Where it's at the state commission regulations will apply. So all these aspects, the state commission, by allowing open access, will look at cross subsidy surcharge, additional surcharge, what kind of tariff is to be allowed, and all these things then come to the state commission. So state is slightly more, CRC is more at the macro level. State is slightly, their hands are dirtier with detail, and they do more work, which is adjudicatory in that sense, which pertains to different players who come and play various roles in the power sector. And also just at the central and the state level, there's also a kind of a grid code, grid discipline. So there's a settlement, like I said, it's like a huge punch bowl. So how you sometimes you produce electricity, but your ultimate consumer is not able to consume that electricity for whatever reason. There's an outage or there's some other factor. Now that power has gone within the system, someone has consumed it. How will you determine what charges, what is to be done? Sometimes extra power may also affect grid stability, whether that can be done, and how is to be done technically. All those things are looked at by both the central regulator and the state regulator.
Oh, there are valuable insights coming in from our to today's session. So now, going ahead with our next question. Now, where there's a consumer and where there's a state-run a company, a generation company, or the discom for that matter, there's bound to be a dispute. So where there's a dispute, if you could in a nutshell explain the hierarchy of forums that are available for the consumer. So from the bottom to the top, what all forums are available for dispute redressal?
See, for a consumer, a forum largely would be under Section 42, which is a consumer grievance redressal forum with a licensee. Now, if there's any billing dispute or anything which pertains to the distribution license, you have to go to the CGRF. You go to the CGRF, then CGRF will pass the order. These are normally officers appointed by the distribution licensee itself. This is what is contemplated under the act. And then there's an ombudsman, and if you're not happy with the ombudsman's order, then you file a writ before the High Court, and then it goes to the normal hierarchy. Now, as far as if you have a consumer issue which pertains to regulations, and this pertains to implementation of regulations at slightly more macro level, and it's not only individual related. For example, the standards of service, or there's an issue which pertains to a certain regulation, then you can also go to the commission. But you'll have to then see in terms of the regulations, how do you make the jurisdiction and how do you plead your case? You'll have to factually fit it in within the framework of the regulations or the CGRF. So that is how largely the consumers work. As far as generation companies are there, generation companies and a consumer, they are beyond the purview of the regulation within the Electricity Act. So a generation company, and this was one of the reforms, that if you have a generation company, you can sell to whoever you want at whatever price. So commission does not need to determine that price, sale price. And once you do, you can have whatever mechanism you want to have, a civil court, you want to have an arbitration clause, you can do that. Now, as far as your industrial licenses disputes are concerned, normally there are arbitration clauses, but like I said, both at CRC and SCRC, the power to appoint the arbitrator normally under the Arbitration Act is with the court, Section 11. But under the Electricity Act, and there are multiple judgments starting with Gujarat Urja Justice Kajju's judgment, then there was PPN power and subsequent judgments. That power of appointment is there with the state commission. Now, under what circumstances, whether a matter is to be referred to arbitration or whether the matter is to be heard by the commission is completely within the prerogative of the commission itself. Now, there was a matter which I did where the matter was referred to arbitration. I was appearing for one of the licensees. It was a dispute interstate licensees. I said these are licensees and this will have tariff implications. So the arbitration should not go on. The commission should only hear because it's your. So the commission still referred the matter to arbitration, and this was a HVPL matter, and I think it was decided finally by Justice Anjana Desai. So I said that this was a 63 project. There was a tariff bidding done. Now, if you do arbitration, this is indirectly increasing the tariff, and this will be passed on because both were transmission licenses. But the added tribunal upheld. They said that it's prerogative of the commission. My argument was that even though discretion is there, but it has to be exercised on some sort of parameter, which are settled parameters in law, on which discretion is exercised. That you can't just arbitrarily refer it to arbitration just because you have a whim. You have to have some basis where you want to exercise. And I have made this argument. You have to deal with it. So this the appellate tribunal said, yeah, it's the discretion because commission is well aware. So largely the appointment power is with the commission. They'll have to see whether um, they want to hear the matter, whether there is evidence to be led. If they feel that there's an evidence to be led and they are not in a position to have detailed hearings, then they may refer the matter to arbitration. No, there was judgment, I think this is called Gujarat Utilities, which said, and this was also there in PPN Power, that each commission should have a judicial member because these are tribunals and sometimes they have to decide, adjudicate upon issues, and they have adjudicatory functions. Therefore, without a judicial member, they can't really be doing justice efficiently if they don't have a judicial member. So now, with each commission, you will always have a judicial member there. If you don't, then there is an argument available to you to raise that this is an adjudicated dispute and there will be consequences if there's no judicial member there. So depending on how you want to proceed, it can be taken one way or the other. But that's how largely even arbitration works. It's the prerogative of the commission. Once they do, then once they appoint an arbitrator, then the rigmarole of the Arbitration Act applies, and you'll have to challenge it under 34, and then it will go under normal procedure under the Arbitration Act.
Now, sir, going ahead, only if you have the time, can we go ahead with our next question, sir? Because
Yes, please. No problem.
going ahead with our next question, sir, we see in most of the law schools in the country, in fact, in almost all the law schools, electricity laws or power laws are not taught, neither as an elective subject nor as a mandatory compulsory subject. So now for someone who wants to explore in this area, branch out, when I'm to my knowledge, there aren't many firms also who are specializing with boutique firms dealing or specializing in electricity laws, apart from a few council chambers who are specializing regularly appearing before the electricity commissions or APTEL, the Appellate Tribunal of Electricity. So what literature or any particular internship or courses would you recommend to them who want to specialize in this area?
See, I think there are few law schools which have started teaching electricity as an at least as an elective subject. Because I was teaching for a couple of years in Symbiosis before the lockdown hit us. And I am also aware of a couple of other law schools who are teaching it as an elective. Now, that being said, there was an issue even when I started. I actually kind of stumbled upon into the sector because I was doing an arbitration, a big arbitration, big ticket arbitration for one of my clients, and it was within the background of the power sector. And for that particular client, then we were doing other arbitrations. And once you're doing arbitrations, I kind of stumbled upon into the sector, and so I also found my way around. So there is no clear cut literature, and whatever commentaries which are there, they will not prepare you in terms of the principles, in terms of the enunciation of law, because there are different parameters which are there in different regulations. It's very difficult for anyone to understand unless someone were to explain it to you. So what you can do is probably you can read at least the landmark judgments. So the Supreme Court, some of them are really, really good. And if you're really interested, then my suggestion to you would be that now there are quite a few firms who are practicing in the power sector. Please join one such chamber and join one such firm, and then see, you'll have to learn on the job. There is no other way. So even in my case, so I was doing some technical matters and I am not from a science background. So for me, it was very difficult. And while doing those matters, I understood. So once I understood, I sat with the experts, I understood. Then that knowledge carried on. So next time when someone else took a counter view, I had my basis and my past knowledge to dispute that and kind of come to a different conclusion and apply my own mind and take it from there. So there is no right or wrong way unless you have some sort of target or you have some sort of matters. You'll have to do it while working within the sector. At least I have not come across a book which would give you the skill set which is required for practicing in this sector.
Very well, sir. And lastly, sir, not so long ago, in a couple of states, well, I'm well aware of the state of Rajasthan. Earlier, we had the Rajasthan State Electricity Board back in 2000, which was subsequently disbanded, and it was abolished and led to formation of five different new power companies: the generation company, the transmission company. Now, do you think this step has really helped? Because now that we have five new companies, and every time we see an advertisement that is issued, there is a challenge that is made. Do you think that it has increased litigation manyfold, or do you think that has really helped in allocation, in role responsibility, and now things have become far more clear?
See, in my experience, and I'll caveat it by saying that this is my personal experience. I feel that it's actually been a step in the right direction, though we should have done a lot, many more things. But it's been a step in the right direction because the state government, though not completely distanced, but has been distanced quite a bit. And the bifurcation of the state electricity boards is been there in the right direction because they had become inefficient. So now this is unpopular, but I'll say this, nonetheless, that a lot of our governments, when they pass their budgets, the problem is there's no public scrutiny. A lot of our governments are already bankrupt. So when they provide these subsidies, it's generally diverted from healthcare or education because that's why we have such a poor system of healthcare. Now there are states, and I'll not say which government has done this, but quite a few governments have realized this and they have started charging the actual cost of power. And what I have seen in my experience is that people, when they get something for free, they don't value it. So I have seen it in various places where power was subsidized. The ACs would be on the entire day. No one was be sitting there. But once the actual cost started was being charged, people became more careful. So we should like with any other. You see, you pay for the food that you get. Why should we not pay for the power that we get? And one of the reasons, if India has to become a manufacturing country, because see, we every sector, every possibility has an upper limit. We have overutilized our services sector and services status. Now, the reason we lose out at the macro level in manufacturing is because the power is very expensive. Now, if you see our SEZ Act, which was there, the SEZ Act was a very good idea, but it was poorly implemented. And sometimes once implemented badly, for the subsequent players, it becomes very, very difficult for them to undo the damage or the undo the structure which has already been created. Now, the idea was in a SEZ that the power will be at the bare minimal cost and the manufacturing will be done, manufacturing will become robust and we'll be able to compete with Chinese industries. Now, just as an example, I'll tell you, like if you look at Haryana, Haryana was one of the early states which started having industries, and Faridabad had a lot of industries. Now, what happened was now you see the power rate in Gurgaon and Faridabad is quite high compared to Delhi, like I pointed out. Now, Delhi, if the cheap of rate of electricity in Delhi is cheaper than Gurgaon and Faridabad, there's something fundamentally wrong which is happening in Haryana. What was happening was, now this is a principle that, just to put it simply, that if an industry goes out of the system, it's buying power from a private source. Now, normally what used to happen was a big consumer would cross subsidize a small consumer. So a farmer or a middle class person was getting subsidized from an industrialist. Now, once the industrialist goes out, he will not be taking that power. So that power, which was now, because these are all long-term contracts, you have to source power. The licensee would have sourced power, so there would be some sort of standing. So there would be a cost, which would be the one would be the standing cost of the cross subsidizing quantum, that they were cross subsidizing other consumers. So that is one aspect. And second would be standing, because I bought this power on a 30-year basis for you. Now you're not taking it. Therefore, this is the amount per unit cost that you have to pay me. Now, once you put that, Now, then the cost of power becomes expensive. Now they are not able to compete with the global industries because your input cost is higher. And it's not that the input cost does not get passed on to you. It's a misnomer that anything is for free. The subsidy that the farmers get, they end up paying high cost in the goods that they consume, because every input cost will get passed on in taxes in the cost of the good that is produced. So nothing is for free ever. But this will make your manufacturing much more expensive. Secondly, what happens is that once these costs are quite high, and that's why, but the national tariff policy and the idea was to initially eliminate cross subsidy completely. But once the government realized it was not possible, then they said that it was to be gradually reduced. So today your cost determination happens within plus minus 20%. So even the poorest of poor, unless you're the bottommost level, they are the only ones who get that benefit. Everyone else is playing around in plus minus 20%, but that plus minus 20% is also quite huge, and which makes your manufacturing inefficient, more expensive, because one, the global, for example, the Chinese labor is cheaper, their power is cheaper. We are not able to compete. So that's why it's very important the power has to be cheaper. And these are all legacy issues. Unless you deal with them, uh, you will have a tough time being a manufacturing hub for the world.
And so, lastly, sir, before we wrap this up, anything that you wish to say to all the viewers who are watching, to young students, law students, young lawyers, any piece of advice that you have for them?
I just have one piece of advice, and that is, please, whatever you want to do, please go for it and work hard. Hard work moves mountains, and if you are willing, you will be able to achieve whatever you set your hearts on. So work hard and all the best. That's all I can say.
Very well. That was a power-packed performance, power-packed session on the power sector, the basics. We were able to cover electricity laws, basics, transmission generation difference, then all the forums that are available for dispute resolution, for dispute redressal. So thank you so much, sir, once again, for taking our time for doing this really very important session to explain such technical terms, terminology that otherwise no other channel would, and do it in simplest of the words, simplest of the languages, so that it's easier for everyone to understand and comprehend. I really appreciate the time, taking out time and doing this for us. To all the viewers who are watching, our email is mentioned on the channel. In case if you still have queries, which I am sure you will not, by the end of it, feel free to write to us on our email mentioned on the channel. We'll be more than happy to forward the same to our Amicus for today's session, Mr. Pathak. Sir, thank you so much once again. It was a pleasure recording this session. It's goodbye for now. Thank you.
Thank you so much, Jay. It was a pleasure being there. And in case anyone has any further questions, and if you think there's sufficient questions and material, maybe we can do another session. I'm always happy interacting or answering questions. Otherwise, also even on my LinkedIn, I don't put up posts normally, but I always try and respond to PMs. So if anyone has any questions, I'm always available. And I hope I was of relevance and of use, and I hope people benefited from whatever little I had to say. Thank you so much for having me.
Thank you
Bye.
so much,
Have
sir,
a good
once
day.
again. Bye bye. Goodbye.